All rise. The First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon. We have one case in the docket for argument this afternoon, the consolidated case of Raven Transport Holdings, Inc. versus Raven Transport Company, Inc. Counsel ready to proceed? You may approach counsel. Counsel, we have allocated 20 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor, 4 minutes, please.
So noted. You may continue, counsel.
Thank you, Your Honor. May it please the court. My name is Joshua LaBeouf, and I, along with my partner Matt Jackson, represent Raven Transportation Holdings, RTH for short, who respectfully requests that this court reverse the final judgments that were entered below that were premised on the summary judgment orders. As a brief background, historically the parties engaged in the transportation of goods for RTC's customers, that's Raven Transportation Company, that's the appellee, listing RTC as the motor carrier, while RTH, our client, provided the logistical support as the independent contractor. Now, there should be no dispute that when moving goods through interstate commerce, there must be at least one company that serves as a motor carrier. So, as between RTC and RTH, our client, at least one of them had to be licensed and operate as a motor carrier because it was only the two of them that were handling these goods.
Counsel, do you agree that Applicability is a licensed motor carrier?
Yes, Your Honor. They are a licensed motor carrier, but that, Your Honor, does not end the inquiry. Simply being licensed does not satisfy MAP 21 because you must be licensed and own and operate the vehicles that are actually transporting the goods. Now, the lower court disregarded, the lower court's order essentially had three fundamental errors. In the first one, the lower court disregarded summary judgment evidence and determined that RTC did not have an obligation to enter into contracts as a motor carrier with its customers. Secondly, the lower court determined that to the extent that it did have to enter into contracts as a motor carrier with its customers, that RTC satisfied that requirement because it simply had an active motor carrier license, while not taking into account whether or not they operated as a motor carrier by owning or leasing vehicles. The third issue that the lower court erred is the lower court determined that even if they are required to own or lease vehicles, that RTC operated as a motor carrier because it either owned or leased the vehicles because the management agreement between the two parties was somehow a lease. Now, turning to the first issue, the ruling that the lower court held that they were not required to have a motor carrier, that they were not required to enter into contracts with their customers as motor carriers, there are three types of evidence that the lower court neglected to adhere to consider sufficiently at summary judgment. That's the management contract language, the historical dealings between these parties, and the affidavits that were submitted by our client RTH in opposition to the motion for summary judgment. Starting with the management agreement language. The very first whereas clause of the management agreement identifies Raven Transportation Company, it's the other side, as a common carrier, which the parties agree that's the predecessor term for a motor carrier. The management agreement provided that RTC was required to have certain licenses. Conversely, the management agreement specifically states that my client, RTH, does not have an obligation to have any licenses. Therefore, as between these two parties, since it was only the two of them, it's clear that they were required to enter into contracts as a motor carrier, because the MAP 21 requires that when you enter into contracts with a customer, that you identify your authority under which you are entering into that contract. So as between the two of us, the lower court erred in reviewing the management agreement.
At what point did Applicability begin violating MAP 21's requirement that motor carriers use their own equipment?
Your Honor, that particular change in MAP 21 would have taken place in 2012, which is when MAP 21 was implemented. That specific requirement is contained in that particular iteration of it. Now, the historical operations between these two companies, the lower court ignored the fact that RTC has always entered into contracts with customers as a motor carrier. RTH, our client, only became a motor carrier in 2014, and approximately 50% of RTC's customers are require that you actually be a motor carrier, not just a broker. So that was the second bucket of evidence, so to speak, that the lower court failed to consider at summary judgment. The third...
Counsel, let me ask you a question about what you just said. Have any of their customers complained that their licensure is inappropriate or that they don't meet the definition of a motor carrier? Have any of their customers or any regulatory authority?
Your Honor,
on that?
I'm sorry, I didn't mean to speak over you. The customers, the record isn't developed enough below as to that particular issue because it was done on summary judgment. So I don't believe the record evidence necessarily reflects that. The last bucket, so to speak, of evidence that the lower court disregarded at summary judgment were the two affidavits that were submitted by RTH, one by its president and the other one by its vice president. Now, these affidavits clearly stated that it was always the party's intention for RTC to enter into contracts as a motor carrier.
Was the issue as to whether or not these affidavits were based on the applicant's personal knowledge?
Yes, Your Honor, and that's what the lower court held. The lower court struck them based on lack of personal knowledge because, in essence, the lower court determined that the president, Mr. Bridges, he was not employed by the company when the management agreement was entered into. But that's not a threshold requirement. We cited to the case of One West Bank versus Jasinski. That's the case that we cited to where being employed by the company is not dispositive to whether or not the affidavit is admissible. In One West, the court, and this was the second DCA, stated affidavits in support of summary judgment are closely scrutinized, but affidavits in opposition to summary judgment are treated leniently, as they should, because the record isn't fully developed at that point. The lower court disregarded the affidavit of Mr. Bill Weiss without stating how or why that particular affidavit was disregarded, and that was on the motion for rehearing. Regardless, at a minimum, there's a question of fact as to whether RTC is required to enter into contracts as a motor carrier.
But big picture, didn't the trial court look at the language of the contract and say it's clear it doesn't impose that requirement, and it would be improper to look at these affidavits to inject that into the contract 19 years later?
Your Honor, the lower court did say that the agreement did not explicitly say that. And we can see that the agreement does not explicitly say it, but it's silent. It's silent. And so when an agreement is silent, you can bring in parole evidence in order to explain that particular silence. Here, we're not introducing parole evidence to contradict the explicit terms of the contract. The contract doesn't say anything, although it does say that they are a motor carrier, whereas my client does not have to be licensed at all, according to the terms of the contract. Now, the lower court's first fallback position was that, well, even if they are required to be a motor carrier and enter into contracts as a motor carrier, they have a license, and that ends the inquiry. Well, that's an overly simplistic view of MAP 21 and the cases that explain.
Counsel, your second, third affirmative defense rests on your interpretation of MAP 21. Regarding MAP 21, how do you interpret MAP 21's requirement that a motor carrier only provide transportation of property with vehicles leased or owned by it? What does only mean?
Your Honor, our interpretation of that particular phrase only is that that is the only manner in which they can appropriately transport goods as a motor carrier. They must only do so with trucks that are owned or leased by the motor carrier. To quote the particular passage that Your Honor is citing to, it says that a motor carrier, quote, may only provide transportation of property with motor vehicles owned or leased by the motor carrier, unless it does so under a different authority, such as a broker or something else. But again, the agreement did not contemplate that. Nowhere in the agreement are they listed as a broker. Now, so it's clear under MAP 21 that not only must you have a license, but you must actually transport the goods with trucks that you either own or lease. Thus, the lower court misinterpreted the law on that. Now, we cite two cases that we think are very instructive with regard to the interpretation of MAP 21 and the fact that you must actually transport goods with trucks that are owned or leased by you. That's the Harris versus Village case and the Sparks.
But getting back to my question again, counsel, when the Fourth Amendment was entered into by appellant, was Applicability only providing transportation with vehicles leased or owned by it? Or was appellant using its own trucks as well?
Your Honor, when they entered into the Fourth Amendment, that was back in 2016, there was, at that particular time, the record's a little bit sparse on this, but they had some vehicles, they owned some vehicles, and RTH, our client, owned some vehicles. But that changed over time. It wasn't until 2019 where the number of vehicles that they owned began dwindling. And that number of vehicles began dwindling to zero. And that essentially is the reason why they can no longer operate as a motor carrier, because they cannot.
But then it went back up to one, right?
It did, Your Honor, but.
Did that help? Did that help?
No, that did not change the analysis, because not only must you own the vehicles, you must actually use those vehicles in the transportation of the goods that are at issue. And those are the two cases, the Harris versus Village case and the case of Sparks versus M&D Trucking. The one truck that they have, they admit, is not being utilized to transport the goods.
Counsel, how do you address their argument, their definitional argument, if I can call it that? You know, that owning doesn't necessarily mean one thing, and that they are within the definition, a broader definition of own or lease. In other words, that they have, you know, you can construe it as, I have the legal right to tell my customers I own this truck because I can control it and I can make it do what they would need me to do.
Your Honor, that definition of owner or lease falls within the Code of Federal Regulations. And that particular definition that they utilize is, frankly, completely out of context, because the Code of Federal Regulations that they cite to is the truth in leasing provision of the Code of Federal Regulations. By definition, it requires that there be a lease. The other side essentially attempts to create a legal fiction that the management agreement is somehow a lease. But when they use the term owner, they use that term because the management agreement provides the other side the ability to have, quote, exclusive use over the vehicles. But the truth in leasing provision requires that, like I said before, there must be an underlying lease. The applicability section of the truth in leasing, and that's section 376.1, provides the regulations in this part apply to the following actions by motor carriers. And then it identifies the leasing of equipment, So what the other side does, and what the lower court did, is essentially did a fourth fallback, if you will, and said, well, then the management agreement must be a lease. But it's important, the historical context of the management agreement and why it was entered into, the fourth iteration, the Fourth Amendment to the management agreement. It was entered into specifically at RTC's request because they did not want to own or lease vehicles for liability purposes. So the intent of the parties was never for the management agreement to be a lease. But regardless...
Does the management agreement say that was their intent? Or you just know that was what their intent was? Well,
that intent comes from the affidavits below, that they never intended, well, that they always intended for the management agreement to be for the other side, to enter into contracts as a motor carrier. But the affidavit of Mr. Bill Weiss specifically explains why they wanted the Fourth Amendment, which was so that they would no longer have the liability of leasing or owning vehicles. Now, the definition of a lease, the other side cites to the provision of the Code of Federal Regulations solely as to what the definition of a lease is. But what they don't do is they don't cite to the 3 other provisions of the Code of Federal Regulations within the Truth in Leasing that specifically provide the requirements for a lease. In essence, they completely ignore Section 376.11, 376.12, and 376.22. 376.11 provides the, quote, general leasing requirements. 376.12 is the, quote, lease requirements. And 376.22 are the leasing between authorized carriers. Now, what these 3 provisions have as a common thread is that there must be, and I'm quoting now from 376.12, they must have, quote, exclusive possession, control, and use. Not just use. There must be exclusive possession.
But counsel, how was the purpose of the agreement frustrated when the Fourth Amendment was executed after MAP 21 was enacted?
Your Honor, the issue of whether or not the purpose is frustrated is generally a question of fact. And here, we're on summary judgment. And so that question of fact was not sufficiently evaluated below, or there wasn't enough before the lower court to necessarily evaluate that issue. So here, the other side cannot use as an excuse, well, the parties must have known that the agreement was eventually going to violate the law. Because remember, we didn't know that. RTH, our client, did not know that until it actually received correspondence from RTC's counsel to our in-house counsel that specifically raised the issue of the problem. So it wasn't until then that we knew that the agreement would eventually violate MAP 21.
Regarding the Applebee's purchase of the truck, how did Applebee's breach the agreement by purchasing a truck that is not used in transporting goods under its customers' contracts?
Your Honor, it violates the agreement because the agreement explicitly provides that all new vehicles should be leased or purchased by RTH. And so by them doing that, they're essentially, on the one hand, admitting that there's an issue by their own conduct. But nevertheless, it's a breach of the agreement because, indeed, RTC was not permitted under the terms of the Fourth Amendment to purchase vehicles going forward. I see I'm into my rebuttal time. Unless there's any other questions, I'll reserve the remainder.
Thank you, counsel.
Thank you, Your Honor.
You may approach, counsel.
May it please the court, my name is Bobby Farnell. With me is John Woodley. We're here on behalf of the appellee Raven Transport Company. Judge Lewis, your first question was, when does RTH allege that RTC first started violating MAP 21? And the answer to that question from their briefing is, well, RTC violated MAP 21 when its percentage of ownership or leasing of the trucks went below 10%. That's what their argument has been. And Your Honor, MAP 21, Your Honors, I did that last time, MAP 21, the provision that they rely on reads, and I'm quoting, a motor carrier under this chapter may only provide transportation of property with self-propelled motor vehicles owned or leased by the motor carrier. There's no mention in there of 10%. There's no mention in there of 50%. There's no mention in there of any percent. The CFR says the exact same thing. The CFR back in 1998, before this contract was entered into, said the exact same thing. The 10% is a straw man that they've created so they had something to shoot down. There is no requirement of 10%. There's no requirement of any percent. The The statute applies to motor carriers, and Mr. LaBeouf is right. There are two motor carriers. There's RTC and there's RTH. And this MAP 21 provision just says, Mr. Motor Carrier, if you're going to haul freight, you need to do it with a truck that you own or lease. That's all it says.
In that regard, counsel, do you agree with Pella that the agreement as amended violates the requirement in MAP 21 that motor carriers provide their own transportation?
I do disagree with that, Your Honor, because that's not what it says. The provision of MAP 21 says, again, I'll read it, a motor carrier registered under this chapter may only provide transportation of property with self-propelled motor vehicles owned or leased by the motor carrier. MAP 21 doesn't say motor carrier, you've got to haul the first stick of furniture. MAP 21 just says if you do haul the first stick of furniture, you got to do it with a truck that you own or lease. So I agree with that. If a motor carrier is going to haul something, it's got to do it with a truck it owns or lease. MAP 21, no federal rule, no federal statute says motor carrier, you actually have to haul stuff. It's like a lawyer. I have to be a lawyer to come here and argue before you, but if I don't argue before you, I can still be a lawyer. I can be doing real estate contracts. I can be doing deeds. There's no requirement in any federal statute that says RTC has to haul freight. If it does, it must do so with the truck it owns or leases. And Your Honor, let's take their 10%, 90% scenario. There's 400 trucks that are used to haul this freight. If my client, RTC, owns 10% of them, it's hauling freight in the 40 trucks it owns or leases. It's not violating MAP 21. His client is hauling freight in the 360 trucks it owns or leases. He's not violating MAP 21. Nobody's violating MAP 21. Let's take it to the extreme. Let's take it to they own 100%, we own 0. We're not hauling any freight. We're not violating MAP 21. They're hauling freight with trucks they own or lease. They're not violating MAP 21. There's nothing about this contract that's illegal. There's nothing about this contract that's been frustrated, and frankly, that shouldn't be the case. The next thing they argue, Your Honor, Your Honors, is, well, MAP 21 requires a carrier to haul freight, and RTC cannot do that because it doesn't own or lease trucks, and that's what we just talked about. MAP 21 does not require anybody to haul freights any more than the Florida Bar requires me to come argue before the court. I'm licensed, RTC is licensed, that's all the contract requires.
Counsel, how can the agreement be considered a lease when Appellee's counsel requested that the parties enter into a master lease agreement to ensure compliance with MAP 21?
So, Your Honor, we only get to the dual ownership.
Was that request an implicit acknowledgement that the agreement is not a lease?
I think the agreement is a lease, but we only get to the lease dual ownership question if MAP 21 requires my client to haul freight. If MAP 21 does not require my client to haul freight, we don't even get to the question of a lease or dual ownership. But it is a lease if we do that. If this court decides, well, MAP 21 requires RTC to haul freight. If that's where we get, the definition of lease in the CFR says an agreement where somebody else, party A gives party B the use of their equipment for a specified term for the transportation of property for compensation. Our contract does all of those things, and it's no accident that our contract does all of those things because that's what the CFR said back in 1998. MAP 21 is nothing new. It's statutorily it's new, but it was in the CFR back in 1998. Our contract tracks the language of the 1998 CFR for the definition of lease and for the definition of ownership. And Your Honor, the contract, not only does MAP 21 not impose an obligation on RTC to haul freight, the contract nowhere says, RTC, you will haul freight. It doesn't say that. There is no obligation. They're trying to create another straw man obligation so they can say, we didn't do it. That's all it is. There's no contractual obligation for that. They also say that RTC has breached its obligation to enter into contracts as a motor carrier. Well, we had 2 years of litigation in the trial court. We had 2 summary judgment hearings in the trial court. We've had hundreds of pages of briefing in this court. There's not a single sentence anywhere in that contract that says, RTC, you must enter into contracts in your capacity as a motor carrier. It doesn't say that. The contractual language that they rely on just says RTC will obtain and maintain any licenses required by the DOT and any necessary or desirable minority carrier certificates. We've done both of those things. The contract.
Regarding the purchasing of the truck, how did purchasing a single truck that is not used in transportation remedy any violation of MAP 21?
Your Honor, they sent a default letter on January 17, 2020, saying that we are in violation of MAP 21 because we didn't own a truck. MAP 21 literally is 500 pages. We're talking about one single little phrase out of MAP 21, but it's literally 500 pages. The owner of RTC said it was easier to go spend $30,000 buying a used truck and parking it than paying me to trying to figure out what MAP 21 says. If that could cure the breach, let's do it, park it and cure the breach. That's why. And Your Honor, I forgot to answer a question you asked earlier about why would we write a letter wanting a master lease? It's belt and suspenders. If there's some question, and we've spent hundreds of thousands of dollars fighting over this issue, if there was some question about whether we had to have a lease, let's just do a lease. Let's call it lease. Let's do whatever we got to do to make sure there's no questions. That's why we suggested that. Easier than fighting it out. Okay, back to breach of contract because we're not entering into contracts as a motor carrier. We are, but there's no contractual requirement that we do. And there's no contractual requirement that we enter into contracts as a minority motor carrier. We're both of those things, but the contract doesn't require us to enter into contracts in any of those capacities. It doesn't care what capacity we enter into contracts. Our job under this contract is to get customers and let them service the customers. That's what they've been doing. Again, this notion that there's a contractual obligation that we enter into contracts in some particular capacity, it's a straw man. It's not there. It's just not in the contract.
How did the appellees getting a broker's license remedy any violation under MAP 21?
If there was a violation of MAP 21, it didn't remedy that violation. All it did is prevent the contract from being illegal or frustrated because RTC can perform all of its obligations under the contract as a broker. Again, it was a belt and suspenders approach. Just in case, let's go get our broker's license because if they're right, the contract's no longer frustrated, the contract's no longer illegal. That's all. That's the only reason. Those were some of the affirmative defenses they asserted: illegality, frustration of purpose. And that reminds me of a question you asked, Your Honor, about how could the contract have been frustrated if MAP 21 was passed 4 years before this contract was entered into? And the simple answer is it couldn't have been. Parties are obligated to know the law. This was the law before the contract was entered into. The frustrating event can't precede the contract. The frustrating event has got to occur after the contract is entered into. That's not what happened here. They're saying that because RTC does not own or lease any trucks in its own name, it's not qualified to be licensed or registered as a motor carrier. Mr. LaBeouf just admitted we are a motor carrier. We have been licensed as a motor carrier since 1986. Nobody can change that except the United States Department of Transportation. After a notice, after hearing, after a 30-day cure period, none of that has happened.
Counsel, you may have touched upon this earlier, but why is the agreement not void for illegality given MAP 21's requirements?
Because, Your Honor, MAP 21, the requirement that they're seizing on just says, if you haul freight, Mr. Motor Carrier, you must do so in a truck you own or lease. Under their theory of the case, we're not hauling any freight. So we're not violating MAP 21. If we were hauling freight in trucks that Mr. Whitley owned, that would be a violation of MAP 21. That's not what's going on. We only hauled freight in trucks, whether we owned or leased everything jointly, as we argue. But if we only own or lease 10 trucks, we're only hauling freight in those 10 trucks. They're hauling freight in the 390 they own. No violation of MAP 21. Even if we don't jointly own everything they own, if we own 0 trucks, we're not violating MAP 21 because we're not hauling freight. I'm not a motor carrier, Farnell. I'm not a motor carrier. I'm not hauling freight. I'm not violating MAP 21. The tort cases that they rely on, Those cases all involve 2 or 3 motor carriers, and the courts are trying to figure out which of those 2 or 3 motor carriers sufficiently controls the driver to be vicariously liable for the driver's negligence. None of those tort cases say what RTH is saying here. None of those tort cases say, hey, Mr. Motor Carrier, if you're not hauling freight, and if you're not hauling freight in a truck you own or lease, you're not a motor carrier. In fact, if you think about it, they say exactly the opposite. They say, hey, Federal Express, you are a motor carrier, but you're not hauling freight, and you're certainly not hauling freight in trucks you own or lease. You're a motor carrier, but we're not going to hold you vicariously liable for that driver's negligence. That's all those cases say. Federal Express is a motor carrier in those cases. RTC is a motor carrier here. That's all it's got to be. That's all the contract requires. The affidavits, Judge Nordby, you hit it right. The judge said, look, this contract is clear and unambiguous. I don't need parole evidence. I don't need to go to the affidavits. Also, Judge Lewis, you hit it right too, because Adam Bridges, the president of RTH, he was testifying about things, about parties' intent 17 years before he even got to the company. He can't do that. He's got to have personal knowledge. Or if he wants to rely on the business records, the summary judgment rule, the rule that was in effect then, says you got to attach whatever business records you're relying on to your affidavit. The only records he attached to for the party's intent on his affidavit was the contract itself. And the plain language of the contract does not help them. So his affidavit provided nothing. His affidavit, neither did Bill Weiss's. Bill Weiss's affidavit suffered from the same defects. But even worse, because Bill Weiss was basing his affidavit on a conversation he had 23 years ago with some other employee of RTH. Those affidavits did not provide anything that would allow the judge to rule in their favor. And I actually think that's all I got, unless y'all have any questions.
Counsel, what is the current status of the parties' agreement? Are the parties still working together?
We continued to sign contracts that they asked us to sign, and I think I mentioned them in the summary judgment papers, Floor and Decor, Procter & Gamble, Molson Coors, several contracts we continued to sign. They continued to haul the freight. They continued to not pay us. So eventually we stopped paying them, and we have a 3rd lawsuit pending in the circuit court now for anticipatory breach of the entire term of the contract. So at this point, we're totally on the outs.
Why shouldn't this issue have gone to the jury?
Because there's no disputed facts. We agree on every single fact. The only question is, what does MAP 21 require? Does MAP 21 make our contract illegal? And it doesn't. I'd hate for a jury to try to figure out MAP 21. It was hard enough for the rest of us.
Thank you, Counsel.
Thank you, Your Honor.
You may approach, Counsel.
Your Honor, sir, may it please the court. There appears to be a fundamental misunderstanding from RTC's side, and maybe that the lower court had below, which is the obligation of the management agreement is for RTC to enter into contracts with its customers. MAP 21 provides 3 methods that you can do that. You can do it as a motor carrier, in which case you must haul the freight yourself, counsel has admitted. 2, you can do it as a broker, which they only received their broker's license after the lawsuit was filed, after these payments were supposedly due. Or you can do it as a freight forwarder. They don't claim to be a freight forwarder, they never have. So MAP 21 does not require that MAP 21 is not a piece of legislation that forces folks to be motor carriers and to transport goods. That's not what it says. But it says if you are going to transport goods, then you must be either a broker or a motor carrier. Now, the management agreement is very clear. We don't have to be a motor carrier. So somebody has to be the motor carrier here. By their silence, they're essentially implying that they can do it as a broker. They now have their broker's license, so they can haul freight as a broker. But that's not what the intent of the parties was. Your Honor's right. That should have gone to the jury, what the intent of the parties were in this particular management agreement. It's not for them to operate as a broker. And in any case, they didn't get their broker's license until after they had been violating it. Now, again, it's them that enter into the contracts with the customers. We serve solely as an independent contractor. That's what the management agreement provides, that we be the independent contractor. Now, because the agreement was structured as such, the dwindling number of vehicles, by their own counsel's admission, the dwindling number of vehicles down to 0 now violates MAP 21. So for those reasons, Your Honor, we request that the court reverse. Thank you.
And thank you, counsels, for your respectful oral arguments this afternoon. We are adjourned.
All rise.